Welcome to today's webinar, Juvenile Life Without Parole, Miller versus Alabama State Respond, brought to you by NCSL. At this time, all lines have been placed on a listen-only mode to provide favorable sound quality during today's presentation. It is now my pleasure to turn the floor over to Sarah Brown. Ma'am, the floor is yours.
Thank you. Greetings, and thank you all for joining us today for the National Conference of State Legislatures 2013 Juvenile Justice Webinar. My name is Sarah Brown, and I am a director in the Criminal Justice Program here at NCSL, and I will be moderating and presenting at today's webinar. This webinar is a partnership project of NCSL's Criminal Justice Program with the John D. and Catherine T. MacArthur Foundation's Models for Change initiative. Our long-standing partnership with the MacArthur Foundation is designed to highlight promising reforms and state approaches to inform state legislative efforts in juvenile justice. The webinar we are bringing you today is Juvenile Life Without Parole, Miller v. Alabama, States Respond. On June 25, 2012, the United States Supreme Court ruled that imposing mandatory life sentences without the possibility of parole on juveniles violates the Eighth Amendment of the U.S. Constitution. The court's rationale extended from previous cases that detail how juveniles are different from adults and why this sometimes can make them less culpable for their crimes. In the wake of the decision, states with mandatory sentencing schemes grapple with addressing the ruling with appropriate actions. Today, we have brought together a panel of experts that will discuss the case, its implications for state policy, and their actions and experiences. Our program will include, first, an explanation of the Miller case from Marcia Levick, the Deputy Director and Chief Counsel of the Juvenile Law Center in Philadelphia, Pennsylvania. She is a national expert on juvenile law and will share with us her expertise on the case holding, rationale, and remaining open questions. Next, I will briefly highlight for you the state legislative actions we've seen thus far in response to the Miller ruling. Finally, we are pleased to have with us Wyoming State Representative Keith Ginnery, Chairman of the Wyoming House Judiciary Committee, to discuss Wyoming's recent implementation of legislation that abolishes juvenile life without parole in his state. Today's webinar will include presentations by these panelists, followed by a question and answer period. To submit a question, which you can do at any time, please use the chat feature on the right-hand corner of your screen. We will try to answer as many of your questions as possible at the end. Thank you again for joining us. I'd like to now introduce our first presenter, Marcia Levick. In addition to her position at the Juvenile Law Center, Ms. Levick is an adjunct faculty member at the University of Pennsylvania Law School and Temple University Beasley School of Law. She was also counsel on record on the lead amicus briefs filed on the Miller case and previous U.S. Supreme Court cases dealing with juveniles in Graham v. Florida and Roper v. Simmons. We are so grateful to have you here with us, and thank you for leading off today's webinar with an explanation of the Miller case. I'll turn it over to you now, Ms. Levick.
Thank you, Sarah, and hello all. Thank you all for joining us today. I'm going to start with just a quick history of the cases that led up to Miller. And this really requires that we just briefly mention Roper v. Simmons, the case that the United States Supreme Court decided in 2005, abolishing juvenile death penalty. Roper was really an opportunity for the Supreme Court, after having upheld the juvenile death penalty in the late 1980s, to revisit the issue and to, for the first time, embrace the developmental research that has continued to inform the court's thinking about juveniles in the criminal justice system and sentencing of juveniles in the adult criminal justice system. Roper was followed 5 years later by Graham v. Florida, the first case before the Supreme Court where it was asked to consider the constitutionality of a juvenile life without parole sentence in a non-homicide case. The particular individual in that case, Graham, was actually given a life without parole sentence under Florida law for violating his probation following a conviction for a home invasion burglary. And then finally we come to Miller versus Alabama, decided by the Supreme Court, as Sarah said, in 2012. And in Miller, the court was asked to consider whether it would extend its reasoning in the Graham decision to life without parole sentences for juveniles convicted of homicide crimes. And the court did indeed strike sentences in homicide cases. However, the court only struck mandatory life without parole sentences for juveniles convicted of homicide. The rationale behind these cases has been consistent since the Supreme Court decided Miller. And the critical underlying point of that rationale is simply that kids are different. And as I mentioned in my earliest remarks, the court in Roper, for the first time, recognized the developmental research, both in terms of behavioral and social scientific research, and increasingly in both Graham and in Miller, the court has also looked at the neuroscientific research regarding the development of adolescent brains and the fact that critical parts of the adolescent brain are still developing throughout adolescence and indeed into the early 20s. So taking that as the overarching principle that kids are different, three critical points that the Supreme Court made in Miller, which again echoed its holdings in both Graham and in Roper, was first to stress that the proportionality of the punishment for juvenile offenders has to be related to the blameworthiness of the juvenile offender. And if kids are different, then the most severe sentences for juveniles will in fact be less proportionate under the Constitution than they would be for adult offenders. Miller also requires that these kinds of sentences be given in an individualized manner. In both Graham, Roper, and then again in Miller, the Supreme Court stressed that we cannot make determinations at the outset about which juveniles will be redeemable, which juveniles will be rehabilitated, and which may, in fact, be irredeemable. And so the Supreme Court has required in each of these cases another principle that juveniles must be treated as individuals. Their individual characteristics must be considered and assessed before we can impose the most severe sentences on them. And, of course, the implications for state policy are that if a state doesn't take the factors related to youth and to youth status into account when imposing the harshest sentences available to juveniles, then states will likely run afoul of the proportionality provisions of the Eighth Amendment and, of course, the cruel and unusual punishment clause of the Eighth Amendment. So let's talk specifically about Miller's holding. Justice Kagan wrote the majority opinion. She was joined by Justices Breyer, Sotomayor, Ginsburg, and Kennedy. Of course, as I said, the critical holding and the main holding of Miller is that the court struck life without parole sentences for juveniles convicted of homicide where those sentences are mandatory sentences. So what's also true is that under the decision, the court essentially has left on the table the possibility that states could impose discretionary life without parole sentences. The court also made it clear in its opinion that before the court can impose these types of sentences, the court has to consider age and circumstances of the individual juvenile, and also Justice Kagan did indicate, and in part she stated this specifically with reference to why the court was not striking all life without parole sentences in homicide cases, was at least the majority's expectation that these sentences would in fact be uncommon for juveniles. Chief Justice Roberts and Justices Alito, Thomas, and Scalia dissented, and they dissented primarily on the ground that they felt that state courts should be able to make these decisions, and state legislatures are entitled to a certain amount of deference in establishing sentencing provisions for individuals convicted of serious crimes. Looking specifically at the factors that we should consider when sentencing youth for serious crimes, Justice Kagan was fairly explicit in identifying characteristics and attributes of youth that she thought were particularly relevant to the sentencing consideration. And so, of course, she mentioned age. And in speaking about age, Justice Kagan included within that considerations of the particular immaturity of a juvenile, the impetuosity and failure to appreciate risks and consequences that is typical of most adolescents. They make decisions impulsively. They fail to consider the consequences. They tend to have a very short view of the future and are not considering what may happen down the road. Justice Kagan also stressed that family and home environment can be mitigating factors. Children who come from more disadvantaged or dysfunctional or distressed home environments without particularly strong family supports may be more vulnerable than other youth to peer pressure and to the likelihood of getting involved in criminal conduct. The court also required that that sentencers going forward look at the circumstances of the offense. What was the extent of the juvenile's participation? Was there peer pressure that may have affected the behavior? One of the things that we have learned and that the Supreme Court has recognized from the research and neuroscientific research available to it is that juveniles in particular are more susceptible to peer pressure, and in particular negative peer pressure. And so Justice Kagan considered that that was a relevant attribute that should be looked at in sentencing juveniles convicted of these crimes. Justice Kagan also thought that the sentencer should look at whether juveniles could have been charged with a lesser offense, if not for his or her immaturity associated with their youthful status. And finally, the court also was particularly concerned with the possibility of rehabilitation. And this last point is really critical to the court's analysis. The reason, in part, why the court has recognized that kids are different is because of its recognition that children have a unique capacity for rehabilitation. Adolescence is a time of change. It's a transient period in development, and juveniles are likely to change over the course of the next significant period of their lives, unlike adults whom, for the most part, we assume their qualities are relatively fixed. So what are the mitigating qualities of youth? Why is it that the research has established that juveniles are different than adults, other than, of course, what we all know in terms of our own common sense? Well, the first is, as we've mentioned, that juveniles are prone to impulsive behavior. They simply make decisions differently than adults. They tend to make them rashly. They're less able to understand or to appreciate the full impact of their actions. So, again, juveniles are not looking far down the road in terms of consequences, but have a very short view of, in a sense, the immediacy of their behavior without thinking about the long-term consequences of those behavior. And then, as we stressed, their capacity for change and rehabilitation, which is closely connected with the fact that adolescence, as I said, is a transient stage of human development. These children will change, they will mature, and they will grow, and for many of them, they will grow out of offending conduct. All of these characteristics together, as the Supreme Court has held in each of these three cases, essentially makes them less culpable for their crimes, even for egregious and seriously violent crimes. And that lesser culpability means that the court has held that in these kinds of severe sentencing scenarios, that juveniles cannot receive the same sentences under the same circumstances as adults are typically and are receiving them currently. One of the big questions that has been left since the Miller decision was decided not quite a year ago is the issue of retroactivity. The Supreme Court itself in the Miller case did not specifically address the issue of retroactivity. This issue is one that right now is percolating across the country. We know as a result of the Miller decision that there are approximately 2,100 individual juvenile lifers who may benefit from the decision if it is in fact retroactive. Those 2,100 individuals, and these are all individuals who are serving mandatory juvenile life without parole sentences, it does not include juveniles who may be serving discretionary sentences. They are spread across 28 states and jurisdictions. And so the consequences, obviously, of the Miller decision extends broadly, and significantly more broadly than the Graham decision, which affected mostly just two states, Louisiana and Florida, and a significantly smaller number of juvenile offenders, I believe about 120 or 130 offenders in the Graham case. We don't yet have a Supreme Court ruling from any state implicated or affected by Miller on this issue of retroactivity. We do have a decision out of the Florida Supreme Court, which was not an opinion, in which the Florida Supreme Court remanded the Louisiana Supreme Court, in which the Louisiana Supreme Court remanded a case for resentencing, but the court did not issue an opinion, and so we don't know precisely what the Louisiana Supreme Court's analysis in remanding that case for resentencing might have been. In terms of other state courts, there are some appellate court decisions in the state of Florida, intermediate appellate courts, which have ruled that the decision is not retroactive. There have been at least 3 intermediate appellate court decisions out of the state of Illinois, which have all ruled that the decision is retroactive, and one of those cases is now before the Illinois Supreme Court. the Michigan Intermediate Appellate Court ruled earlier this year that the decision was not retroactive. In some related litigation that was pending before the United States District Court in Michigan, the federal judge in that case, within the last few weeks, issued a decision ruling that Miller is retroactive. We also have the issue pending before state Supreme Courts in Minnesota and in Pennsylvania and in Missouri. So the answer to this is that we don't have an answer. There is a fair amount of view across the country within the advocacy community on the advocacy side that the decision is retroactive. There are certainly many prosecutors across the country who have opposed retroactivity. I do know that most recently in Minnesota, the U.S. Attorney in the state of Minnesota did in fact concede retroactivity of the decision. So we don't know where this is going to end up. But we obviously will be watching this because it has significant implications for not really legislative decisions going forward, but for the potential for resentencing or not of these 2,100 juvenile lifers currently serving a mandatory sentence. There are also other open inquiries about Miller since Miller came down. For example, in the Graham decision, when the Supreme Court struck mandatory life without parole sentences for juveniles convicted of non-homicide crimes, the Supreme Court required that juveniles must be given a meaningful opportunity to reenter society. And the Graham decision has continued to actually spark a fair amount of litigation itself in terms of what does a meaningful opportunity for parole or for release or for at least the opportunity to be considered for release. What does that mean? At what period of time does that kick in? How long is too long, for example? And for the most part, this litigation has been done in the wake of Graham. And there we have state court decisions that, again, are varied and are not providing an explicit timeline. The California Supreme Court, in a non-homicide juvenile life without parole case, ruled that a 110-year sentence was too long. There are cases out of Florida which have ruled that a 50-year sentence is not too long, that is long enough for someone to be considered eligible for parole. Other cases that have said 90 years is too long, 70 years is not. These cases are working their way up to the state Supreme Courts in a number of states around the country. And so this is something that we will be watching. I think that we should assume that courts ultimately will be consistently applying the same kinds of timelines. The U.S. Supreme Court's requirement in Miller and in Graham that juveniles have an opportunity to demonstrate growth and maturity and to have an opportunity to make their case for reentry, which is the reason why the court struck these life without parole sentences, ultimately is going to have to be measured, hopefully, in some consistent way, and states will have guidance about at what point they must first make juveniles eligible for parole. And I will stop there.
Thanks so much, Ms. Levick, for your insightful presentation on such complex cases and issues. As a quick reminder to our audience again, you can use the chat feature on the right-hand corner of your screen to ask a question, and we will get to those following the presentation. We will now turn our attention to state legislative actions responding to Miller. Over the past decade, significant rulings at the federal level, such as in Miller, Graham, Roper, are helping to reshape state juvenile justice policies. As Ms. Levick highlighted, the Miller case and previously mentioned cases left resulting policy implications for states. These include that when imposing the harshest sentences available to youth, states must now take into account the age of the offender and circumstances of the case when doing so. At the time of the Miller ruling in 2012, 28 states had mandatory life without parole sentencing laws for juveniles, as you can see highlighted on this map. Interesting to briefly note, 2 states had already removed mandatory sentences for juveniles even before the Supreme Court decisions in Graham and Miller. In 2006, a Colorado law ended the sentence of life without parole for all youth in the state. The Colorado General Assembly set the alternative maximum sentence for juveniles at 40 years without parole. A few years later, in 2009, a Texas law enabled youth ages 14 to 16 who were found guilty of a capital felony to apply for parole after 40 years served. So similarly, both laws use the 40 years as their benchmark time for a new length of sentencing. Now I want to move on to highlight actions taken in 2012 after the ruling last June. Several states, such as Connecticut, Michigan, and Pennsylvania, had varying committees and commissions study the issue in the wake of the ruling. And Pennsylvania's actions resulted in law after public hearings were held last July on how to implement Miller. North Carolina also enacted a law addressing juvenile life without parole in 2012. Both the North Carolina and Pennsylvania laws left juvenile life without parole as an available sentence for first-degree murder, but abolished the sentence for second-degree murder and for felony murder. The Pennsylvania law also specified that the least restrictive punishments be used in the sentencing of juveniles, and that juveniles must receive the same protections before a district judge that they would receive in juvenile court. The law also specifically states that courts will have to impose a minimum of 35 years to life for youth aged 15 to 17 and 25 to life for youth 14 years and younger. Next, we turn our attention to California. In October of last year, California passed the Fair Sentencing for Youth Act, SB 9. Interesting to note about the California action is that the state already had discretionary life without parole sentences for juveniles in the state. The new California law allows juveniles to ask the court to review their case and consider a new sentence that permits parole after serving 15 years. If an offender's petition for resentencing is turned down at that point, the inmate may ask again after 20 years and then again during their 24th year in custody. I also want to briefly highlight the executive action taken immediately after the Miller ruling. 3 weeks after the Supreme Court's decision in 2012, the governor of Iowa commuted the sentences of 38 individuals serving mandatory juvenile life without parole sentences to a new mandatory sentence of 60 years. There is now litigation in the state currently challenging this. And this year, in the Iowa legislature, House and Senate study bills were introduced that allow for eligibility for parole after 60 years, unless the court finds on the record compelling reasons to justify a life sentence without the possibility of parole. Since we've covered the 2012 actions, I'd like to now move forward to highlight this year's state legislative activities responding to Miller. As I mentioned, the first state to enact such a law was Wyoming with HB 23, but I'm going to leave the details on that for our next distinguished speaker, Representative Skinnery of Wyoming, who will share his role and experience with the law's implementation. South Dakota also enacted a law, SB 29, which replaces juvenile life without parole with a sentencing range that would give judges discretion to be able to sentence a youth to any determinate number of years or to life. And Utah's very recent new law, SB 228, abolishes the sentence of juvenile life without parole for a number of offenses, but the bill as written retains juvenile life without parole as an option for aggravated murder. The next map highlights the approximate 15 other states in 2013 that have introduced measures that are currently pending in committees in their legislatures that address juvenile life without parole and Miller. I won't list in detail what all of them do, but overall in the measures, mandatory juvenile life without parole sentences would be replaced with an alternate sentence of a term of years before parole eligibility. It is the amount of years that tend to vary from 15 up to 60. Let me highlight a few examples of these bills. For instance, Virginia's SB 809 would replace mandatory juvenile life without parole with the next lesser sentence of 20 years to life, while the Washington bill provides for juveniles convicted of aggravated murder to a sentence between 20 and 35 years. It also allows juveniles sentenced to more than 20 years to petition the court for early release after serving 20 years. The pending legislation in Delaware would end juvenile life without parole and replace it with a sentence of 25 years before eligibility, while the Alabama bill provides an alternate sentence of a maximum of 40 years for such parole eligibility. We see in the Connecticut and Massachusetts legislation replacement of life without parole sentence for juveniles with periodic opportunities for resentencing. In all of these approximate 15 state measures, we see that 11 of them contain in the bill language a sentence that states this is to comply with the Miller ruling. I want to close this portion of the webinar with a mention of additional NCSL resources available to you. Throughout the year, we will continue to track this important issue for states, produce publications with updates, and incorporate it into our juvenile justice meeting programming. For example, this summer, NCSL's annual legislative summit is in Atlanta, Georgia, on August 12th through 15th. We will have a juvenile justice issue forum session there on adolescent development research and distinguishing adults from juveniles, which will touch on these issues covered today. We are also always available for ongoing technical assistance in your state as you work on these issues. We additionally plan to write and produce a briefing paper on this topic and plan further meeting programming in the future. Finally, this webinar in its entirety will be archived and posted on our juvenile justice webpage next week. We will now turn our attention to Wyoming. We are very honored to have Wyoming State Representative Keith Ginnery with us today to share his state's experience with getting Wyoming's legislation enacted into law in early 2013. Representative Ginnery represents House District 23 in the state, is an attorney and the current House Judiciary Chairman in Wyoming. Committee Chairman, Representative Ginnery, we thank you for taking the time to be with us today, and I turn it over to you.
Thanks, Sarah. Let me walk through sort of the Wyoming's experience and how we actually got around to passing this bill. In each state's a little different. In our state, we only meet in January and February every year. So in what we call the interim between the sessions is when we do a lot of our work, especially in the Judiciary Committee. And what occurred here, this case came out in late June, and we actually had our interim topics all ready for the year, but Management Council, which is our leadership, both the House and Senate, asked us to add this as an interim topic. So we spent some time in July and then some more time in the fall holding some hearings and taking testimony. And primarily a lot of it was led by our Attorney General. He had one path that he was suggesting, and then our county prosecutors had a different path, and so we sort of had two choices sort of to look at. The Attorney General was sort of suggesting what we ended up with, and I'll explain that here in a second. The county attorneys were sort of moving more toward the idea of just expanding the sentencing hearings to comply with some of the things that Kagan was suggesting that you do. So what our county attorneys kept pointing out to us is that that Miller did not say that a juvenile could not be sentenced to life without the possibility of parole. What it did say is that such a sentence required consideration of individual characteristics and can't be automatic, of course. So they were wanting to expand the sentencing hearing and just really key on this individualized sentencing. And we certainly talked about that for a long time. So those were sort of the two different approaches that we were getting and the two different advice we were getting. And so we held hearings, and then in November we approved it as a committee-sponsored bill. It passed out of the House in January, and then out of the Senate in February, and got signed into law this past February. And if you want to take a look at it, we have a link there. You can look at what we wrote on our website. It passed out of the House 42-17, but then passed the Senate 30-0. And the reason there was a little bit of disagreement in the House, there were still some people in the House that thought maybe we should go with more of the individualized sentencing idea and keep that. And in the end, we decided not to go that direction. To understand sort of what we're doing, you have to sort of know what our prior law was. And when we held these hearings, I bet you the first part of that, we spent quite a lot just getting educated on what our law was in our state. And that's the important part to start, because everyone's sort of a little bit different. In our state, we had three options when you're sentencing a juvenile on first-degree murder. You had life, and then you had life without the possibility of parole. Of course, not death, of course, but just so those two were the two options that they had. In our state, it's a little unique, and maybe other states have this. Our governor could not, he can't commute a life without parole. sentence. So once a person got a life without parole, they had that. And that was actually in our Constitution. So that was problematic as to the mandatory aspect of the ruling. So again, we had these hearings. They went on for a while, and really what we came down to, and I think what's most important to talk about here, is which way to go. Do you do expanded sentencing hearings, or do you abolish it altogether? And we ended up abolishing it altogether for a lot of different reasons. But and we could have gone either way. They were both fine. What really it came down to was just the concern over habeas corpus in the federal courts. We were concerned that as these sentencing hearings, if we went that direction, that more and more people, more and more of these juveniles, as they got older, would keep appealing, and that we were going to have a cumbersome issue there. Because how Kagan wrote it, it's somewhat wishy-washy as to what are these considerations you're supposed to take into account, and each they're very subjective, and so that's what led us in the other direction, as our Attorney General was sort of pushing us to go the other direction and abolish it altogether. Again, what was very helpful by doing this both in the Senate Judiciary and the House Judiciary meeting together, by the time we got to the session this year, quite a few people were educated on the issue, and it was ready to move through, and it moved through in relative ease. So what we ended up doing was, we don't have a life without parole anymore, but you can sentence to life. That's the option. But so that they have this, what they called a meaningful opportunity for parole, what we said was, if the governor commutes your sentence to a term of years, so let's say the juvenile's gotten a life sentence, the governor could go ahead and commute it down to a term of years. Or if the governor hadn't done that for this person, after 25 years, so after they have served 25 years, so good time and all that didn't figure in. It was a true 25 years after incarceration had begun. Whichever one of those happened first, they then would be eligible to at least go before the parole board. Not guaranteeing they would be able to get out, but they would be eligible at least for looking at parole. We didn't put anything in. We actually had a provision talking about retroactivity and talking about whether or not we were going to allow those that are presently serving a life without parole, whether or not they got a new hearing. We left it alone, and most of them actually have filed. We're a pretty small population state, 500,000 people altogether. So we don't really have that many of them, but we do have a few, and they've filed to have these new sentencing hearings. So they're going to have a new sentencing hearing to look at those particular aspects. And so we did not actually weigh in on that issue of the retroactivity. We saw it more procedural than substantive. We thought each defendant could apply on their own. We did talk about, increasing the term. There was some discussion about doing 50 years, things like that. We decided this was sort of the better way of doing it, leaving it at life, and then at 25 they could ask for parole. If you're wondering where the 25 came from, to make sure it wasn't arbitrary and capricious, primarily that is our second degree murder is 20, and so we tacked 5 years to that. So that there's some things with our first degree sexual assault. So there was some thinking as to where we got the 25 from. But primarily what our final decision came down to was just concern over ongoing legal hearings that would occur where people were going to keep filing habeas corpus. We thought that they, every 5 years they might come in and say, hey, last time that they ruled on this, my age was different, or, new evidence as to the maturity level at the time of the crime. And we really tried to go that direction, and because we sort of wanted to keep it in place. There was a lot of push, especially from victims of victims, families that did not want to see us get rid of that. And once we assured them we weren't dealing with their particular case, we were going to let the courts deal with that. These were for future cases. That eased some concerns. But that primarily is what we did here in Wyoming.
Thank you very much, Representative, for taking the time to be with us today and walk us through Wyoming's new law. Let's take some questions now from the audience. And I see we have a few that have come in here. So if we are unable to get to your specific question because of time, we will be happy to follow up with you after the webinar and address your inquiries. So I will ask the questions here to my panelists, and feel free for either one of you to chime in. I am seeing here one. Representative, can you please say a bit more about the hearings of the interim committee held last fall, just as far as the different testimony and whether there were victims there or how that went, whether it was contentious and that, just a little bit more on those hearings.
Sure. There was some contention at the very beginning because there were families of victims, and it just awful stories. I mean, just the acts done by some of these juveniles is unbelievable. So some of those families came in. They were worried that we were going to automatically make this retroactive, and they wanted us to clearly understand what had happened to their family members. And once we made it clear that we were not weighing in on the retroactive aspect, this was for in the future, and we made it very clear that we understood that the juveniles who commit these horrendous acts, they are not victims. I mean, these are, in some of these cases, it was just atrocious what some of these juveniles had done, murdering their victims. So once we got past that with some of the victim families, I think people understood more what we were trying to accomplish, and that really we were trying to, essentially it came down to big question. Do you go with the expanded sentencing hearing, or do you abolish the life without parole completely? And that was sort of, it came down to that being the policy question.
Great. Thank you. Marcia, I've got a question that's come in. In the Miller opinion, Justice Kagan explicitly listed the developmental factors that a judge or jury need to consider when sentencing a youth for a serious crime. She explains that these factors are all based on the very real biological and developmental differences between kids and adults. How are states implementing these factors and incorporating them into legislation that seeks to comply with Miller, particularly with regard to the length of sentence and parole eligibility?
Well, I think that's a great question, and the truth is that we don't know exactly yet how the states are going to incorporate this because we're still very early in the process. We have seen probably not more than a handful of explicit Miller resentencings taking place. And depending upon whether there is a new statute in place, which is a situation that we do have in a couple of states, whether those statutes are retroactive or whether or not the states are expressly applying Miller, I think what we're seeing is this ambivalence on the part of states and I think a confusion on the part of states about figuring out where to draw that line. So while you may well have states looking at the particular factors that Justice Kagan identified, if they feel bound by statutory language, for example, in Pennsylvania, we had a resentencing within the last year in Philadelphia where, while the judge considered the Miller factors, the judge also felt bound by our new state law, which Sarah outlined, which requires a minimum mandatory sentence of 35 or 25 years to life as an alternative to juvenile life without parole in first-degree cases, depending upon whether juvenile is 15 and older or younger than 15. So I think in a way it's too early to tell exactly how these factors will play out and whether or not courts will be able to discern where that point is in a sentence that properly takes account of the state's ability to sentence harshly for severe crimes and certainly for homicide crimes, but also the degree to which those factors require that states provide some point during the course of that sentence that juveniles can, in fact, be considered for parole eligibility. So great question, and I wish it could be more specific, but I think we're just a little bit too early in the process now to know how they're playing out.
Great. Thank you very much. I've got a question that came in here. I think I can address just about the status of some of the 2013 measures. The question reads, you mentioned that approximately 15 states have pending measures this year. Are all the bills still pending in committees, or have any passed one of the full chambers? As far as I'm aware of, I believe this week, on checking the status, they are still pending in their respective, usually Senate or House Judiciary Committees, except for the ones that I mentioned in my presentation that have actually been signed into law. But I will certainly do a final double check and email you if any of those status have changed. Again, this is a good opportunity for me to plug our StateNet juvenile justice database that we have on our website. But you can track and watch all juvenile justice pending legislation there, get updates, and can follow those bills that way as well. So let's take another question here. Marcia, this one sounds like it would be good for you. Do you anticipate any other juvenile sentencing cases to reach the United States Supreme Court? And it's fairly speculative, I guess, considering you've mentioned all the different various state courts and whatnot. So that's kind of a biggie. But is there anything that we've had in the last decade reach the high court, and is that something in the field that people anticipate further, or are we sort of done for now with the U.S. Supreme Court?
I think there are three potential issues that I could identify that might make their way to the Supreme Court sometime in, let's say, the next 2 to 5 years. One issue is actually the retroactivity of Miller, and I think this will depend a lot on what happens before the state Supreme Courts as it's playing out right now. If ultimately the decision is held retroactive across the states, and I don't think it will go up, but certainly I think that's an issue that's hanging out there. Related to other sentencing kinds of issues, I think there are two issues that are percolating in the lower courts. One is after Graham, and I think we'll start to see it after Miller as well, is this question of virtual life or effective life without parole versus an actual life without parole sentence. And so I mentioned the California Supreme Court that had struck a sentence of 110 years to life as being violative of Graham, even though it was not technically called a life without parole sentence. That issue, there are two cases before the Florida Supreme Court in which 70 to life and 90 years to life sentences are being challenged as being violative of Graham again. Virtual life without parole sentences is the argument, though not technically juvenile life without parole. I think that issue, I certainly expect that there will be cert petitions filed before the U.S. Supreme Court on the issue, depending upon, I suppose, how prevalent or whether or not four justices on the Supreme Court ultimately think that Graham for now and potentially Miller, as these sentences start to play out under Miller, if it looks like the court needs to clarify what it means by juvenile life without parole and whether it means technically that those magic words are used, or if in fact virtually life without parole sentences, lengthy sentences that provide no real opportunity for parole consideration, then I think the court might take that up. The third issue that might make it to the U.S. Supreme Court at some point in the future is the issue that didn't capture the majority in the Miller case, and that was the issue of felony murder. And in the Miller decision, Justice Breyer, along with Justice Sotomayor, concurred and suggested that in their view, life without parole sentences should not be available to juveniles who are convicted of felony murder, who were accomplices at the scene, sometimes even not even at the scene, but convicted of homicide based upon a transferred intent theory under the felony murder doctrine. That issue, I think, again, not immediately, it did not capture the majority's interest in the Miller decision, but I suspect that issue will also present more opportunities for litigation going forward.
Great, thank you. We got a few more coming in here. Representative, maybe I'll start with this on you, and you can tell us how it played out in Wyoming, and then perhaps Marcia could follow up if she has any insights. The question reads: Given the emphasis on the ability to be rehabilitated, have any states put emphasis on rehabilitation as a prerequisite for parole consideration? And that is the question to the panelists.
Sure, and that's how the parole board works. I mean, I assume in their state too, but in our state, that's what the parole board looks to, is a myriad of different factors to whether or not to grant the parole, and one of those being how much is this person rehabilitated. So again, what Wyoming did was, all we said was the person has the opportunity for parole. Once they've served 25 years or the governor has commuted their life sentence to a term of years, they have the ability to go before the parole board. Now, the parole board could look at the person and say, no, you're not being released. You have not been rehabilitated enough, or there's other factors, such as committing further crimes while in prison, those types of things. So I think that, I don't know if that needs to really be built into any legislation, because that's assumed in the powers and duties of a parole board.
I would supplement that just by adding that I would agree with the representative. Certainly, I think in the Pennsylvania law, there was no specific discussion within the statute itself dealing with sentencing what might happen for the parole board. But I would note that one of the things that we do know is true in many jurisdictions is that juvenile status, the fact of having been convicted as a juvenile of a serious crime, actually counts against juveniles in the parole consideration. So in a sense, they go into it with extra strikes against them. This is written into parole guidelines. I know that this is true in Florida, and there are other jurisdictions as well. So I think that the question is an important one, because it may be that while I think we've somewhat taken for granted that the parole process will play out as it has traditionally, and now we'll have a new class of offenders, juvenile offenders, potentially eligible for parole consideration where they weren't before, it may be that we actually have to rethink how the parole process and how that consideration actually takes place with respect to this population.
Great, thank you. I've got one here that I have the answer to, I think. We have a question on the states that have the biggest population of offenders that are currently serving juvenile life without parole sentences. I don't think we got into this during the presentations. I have information about at the time of the ruling. Again, 28 states had such sentencing laws, and the highest state populations were in Pennsylvania with approximately 450, Michigan with 358, Louisiana with 332, Florida with 266, and California with 250. I can certainly email and follow up with it. Those numbers have wavered, but that was what I have in there. I've got a question to the group. In a state that does not have parole, a sentencing scheme that states, quote, shall sentences to life if the sentencing court considers factors of youth and finds life is appropriate, end quote. Please share your opinion of whether this would violate the Miller opinion. Marcia or Representative?
Well, I'll step in. Generally, I think that it would for this reason. I think that it's important to remember that the Miller decision, as well as Graham, don't specifically say that there has to be an opportunity for eligibility for parole. It's really that there has to be an opportunity for the individual to be released before the expiration of his sentence, for the individual to reenter society. And I think that it's been generally understood by many of us who have been following these cases that that could as easily go back before the sentencing judge or another sentencing judge. So in a state like Florida, for example, which does not have parole, there are different opportunities and different remedies that are being explored. One, of course, is to consider in a sense, maximum sentences that ensure that an individual will have the opportunity to be released before the end of their lives. But the other option is also to consider whether or not there is an alternative review mechanism, such as returning to the court, that could provide that review. So I think that simply a life sentence that never allows for any opportunity for consideration for release before the expiration of that life sentence, I believe, would violate Miller.
Thank you. Let's see, we got some more questions. We have a question about if the panel, anyone could speak to any successful resentencing. It's a kind of a brief question, but can either of you speak about any successful resentencing incidents? And I think
I don't. Maybe Marcia does.
Yeah, I was going to say, I think, again, it's with respect to Miller itself, I think that we're too early in the process. I think you either have states that are waiting on the retroactivity resolution or are passing legislation and waiting on the application of that legislation, much of which is very much in flux right now. We have experience from Graham, and I think the Graham experience in Louisiana and in Florida primarily have been, frankly, all over the lot, where there have been sentences meted out that provided for realistic opportunities for individuals to have an opportunity to get out and to reenter society. And then we have many other sentences which are in this range of 60, 70, 80, 90, 100 years, and many of those are now being challenged in the courts. So I think that across the country, I think that courts as well as legislatures are still struggling to figure out exactly what the practical application of these rulings will be.
Great. Thank you, Marcia. Well, I think that's our last question, and I think we'll wrap up now, but certainly we want to thank all of our distinguished panelists for shedding light on this complex case and issues for states. Marcia Levick, Representative Gingery, we thank you very, very much for your time and presentations today. Also, we want to thank all of you out there for joining us on this important and very timely juvenile justice issue. Again, an archive of today's webinar will be available next week on our juvenile justice website if you want to review any portion of it or if any of your colleagues were unable to join us live today. We at NCSL invite you to call on us with questions on today's webinar, and be assured that we will continue to track, provide updates on this issue, and are available to assist you. Please just contact our office. Thank you all very much, and have a wonderful weekend.
Thank you. That does conclude today's webinar. We thank you for your participation. You may now disconnect your lines and have a great day.